Welcome today to our 6th edition of Ask the Expert here at Farley&Ferry. We're thrilled to welcome Jessica Witmer. Jessica is an attorney at the law firm of Nemad, Perillo, Davis, and Goldstein. And today we've asked her to speak to the executive order from Governor Murphy, Order 128, which revolves around security deposits. It's a huge topic, very controversial for us in the real estate world. And quite frankly, we have to work through it very cautiously and make stellar decisions as we move forward to represent both buyers and sellers. And always our goal is to act fairly. And in this situation, we need a lot of expert advice because we want to work with precision and represent all our clients properly. So Jessica, we'd be thrilled to have you comment on this new Executive Order 128.
Mary Lou, first, thank you for having me today. I'm grateful to be here. And you said it well, Executive Order 128, it's unprecedented territory that we haven't seen before. And what it allows is it allows a tenant to apply their security deposit toward their rent. And it's not a hard process. They just have to provide written notice to their landlord, and it can be electronic via email or via text message. My suggestion for the tenant would be to do it via email, and if they're able to do a read receipt, I would suggest doing that so that they know that the landlord has received it. And on the landlord end, I would recommend that they keep a good record. If they're going to apply the security deposit toward the rent, I would recommend that they have a record of that so there's no issues further down the line stating whether the security deposit was in fact applied.
Now, Jessica, is there a time frame when a tenant can elect to make this decision and notify the landlord?
Yes, there is. So it was effective as of when the order was signed, which was April 24th, and it will go 60 days after the public emergency is lifted. As of yesterday, Governor Murphy signed another executive order extending the public emergency another 30 days. So we're looking at the beginning of June, and then they would have 60 days after that.
Now, perhaps you opt to use your security deposit as rental payment. Is there a process which you must replenish that security deposit in accordance with Order 128?
For the current term of the lease, it does not have to be replenished. However, if they're going to renew their lease, it would have to be replenished on the later of 6 months after the executive order is lifted, the public emergency, or at the time that the amendment is signed. It's the later of the two.
In replenishing the security deposit, can it be handled in installments so it's more comfortable and economically feasible for a potential tenancy?
The landlord can't require that it be replenished before that time. However, if the tenant wanted to replenish it just to have that in there, they could work out something together that would be appropriate for both of them and that they would both be comfortable with moving forward. And the executive order does still allow landlords to seek payments if there was any damages to the property during that time that they would normally be allowed to seek under the lease terms. They're still able to seek that from the tenant.
Now, perhaps we entered into a lease agreement today for a new tenancy. Would that apply to a brand new tenancy as well?
And it would. So it would be any lease that's signed as of the effective date or before April 24th, and then after 60 days after the public emergency is lifted, any of those lease agreements would fall under the purview of this executive order.
Now, we routinely work with commercial properties as well and mixed use investment properties. Is this security deposit matter across the board for any type of real estate transaction or investment?
It does not apply to commercial leases. However, we do represent a lot of commercial tenants and landlords. I'm sure you work with a lot of commercial tenants and landlords as well. And what we have been seeing to handle this hardship is tenants and landlords are working together, potentially allowing a tenant to have a deferment of, say, 60 days, a certain time frame, and get that in writing. And after that, that payment would be amortized over the remaining life of the lease. For example, if you were going to miss 2 months right now, you could take those 2 months and amortize it over the remaining term of your lease when you're able to start paying. And it's something that a landlord and tenant should speak with their real estate agent about and their attorney and make sure that they get something in writing so that there's a meeting of the minds and they're both on the same page.
Would you mind if I discussed a little scenario with you?
No, not at all.
Okay, so perhaps you have a tenancy and they lost their employment. So they decide to use their security deposit for their rent for the month of June. When July comes along, they still don't have funds available to pay their rent. And, they're kind of in a quandary. What should I do? I don't want to get evicted. And now we have landlords in a position that someone's 30 days late or 60 days late. Can they apply for eviction, or eviction is still paused? Or how would you suggest both sides handle that matter?
My suggestion right now is, because the courts are on hold and there is likely going to be a backlog with the courts once all of this is lifted, my suggestion is that the landlord and tenant try to work out something together, maybe similar to what I just spoke about with the commercial tenants. If they have a 60-day period that they're unable to pay, then they take whatever that amount was and amortize it for the remaining life of the lease.
For sure, yes.
What's really important right now is that tenants and landlords should really be trying to work together and come up with an agreement that's fair to both sides during this time.
So it's really a lot about communication and acting fairly and honestly with each other and explaining the situations so that the tenant can remain in their home and the landlord still has a payment plan, so they'll eventually be compensated for, and so we can all really work well together and work through the situation.
Exactly. And one thing to note is, right now there is a constitutional debate on whether this executive order is valid under under the New Jersey Constitution and federal Constitution, and whether the governor has the power to do this. So that's something to pay attention to as well going forward. See if anything develops with that.
It can get a little complicated. I think that if you did have a difficult tenancy and they were creating, some real dissatisfaction for a landlord, it would make it very, very cumbersome for the landlord to evict the tenant. So I guess it becomes problematic if the tenant really isn't communicating and acting fairly. And how do you move forward with that? You just, the courts are not available, and it makes it difficult for attorneys for sure.
Yeah, and if that's the case, I would discuss it with your attorney and see what your options are. There might be, depending on the circumstances, some sort of emergent relief that they might be able to seek, depending on how extenuating the circumstances are. So it's something that an individual want to speak with their attorney and their realtor about and see what their options could be based on their factual situation.
So Jessica, if a lease was signed after the executive order and the landlord wanted to insert a clause to basically delete that particular order, is that something that would be recommended?
I wouldn't recommend it. They could put it in there, but it's likely, based on Executive Order 128, that it would be unenforceable, because you are taking away a right that is given through that executive order. You could put it in there, but you would be running the risk that it could be challenged down the line if the tenant did want to apply their security deposit towards their rent. So it's something that is open to challenge if you did that.
Okay, so the fact remains that the order's in place and we have to be in compliance, especially within the next 60 days.
Yep. And like I mentioned earlier, there might be constitutional challenges that are brought in court, which could change this, but as of right now, it is in place.
Yes, it's, for us, it's a very unique time because, of course, our goal is to sell real estate. And most importantly, we want to represent our clients so they acquire properties that make sense and enhance their economics. And, we have to be so careful when we're representing both sides and trying to give good advice. So we really appreciate you, speaking with us today and sharing your knowledge, and, you're an expert in your field. And if we have any, further questions, as things unravel and unfold, we certainly want to reach out to you, because I really appreciate how knowledgeable you are. It's just that there's so many questions out there, and again, we want to give the right answers and make good decisions for all our clients.
Yep, and we're here to help, and we are updating our website frequently with executive orders that are coming up, just to keep everyone informed on what's going on. And we're available if anyone needs us.
Our tenants and landlords out there listening today, we know it's a difficult time, but resiliency and communication and helps you work through all these struggles. So communicate with each other, be kind, be fair, and remember, we're resilient. We can do this. So again, we are just super thrilled to have Jessica with us today as our advisor, and her guidance was really exceptional. We really appreciate your time and your energy today during these different times. And you know, everyone out there who's listening, please don't forget to subscribe and share, and we appreciate you tuning in for this very knowledgeable session. Thank you again, Jessica Witmer.
Thank you, Mary Lou. It's been great. It's been a pleasure.